Before I get to the cover letter, I want to begin with showing the 5 direct deposit payments made by Google to me for earned ad revenue. Next are the generated ad revenue information via my AdSense account connected to my YouTube channel. Take notice of the very, very small generated ad revenue incremental amounts that were generated over the course of each month to month from 2016 through 2020. Small amounts averaging $3 to $5, at times earning $2 to $3 in ad revenue over the course of 3 months. In 2017, there were ad revenue amounts earned ranging between $20 to $60. This is when I began noticing the start of the flagging, unflagging, and reflagging cycles, which continued well into 2020, which proves the defendants immediately began breaching their contract, which preceded the defendants then resorting to falsely claiming violent content in a particular video to prevent ad revenue from being earned, and finally making the unwarranted decision to completely demonetize my YouTube channel for allegedly stealing videos from other YouTube channels and uploading the alleged stolen video content to my YouTube channel, which the defendants have yet to prove. The defendants have no answers whatsoever to the flagging, unflagging, and reflagging cycles, untruths about video content, and age restricting my videos that were not in violation of community guidelines, then going a step further in sending me emails stating certain videos were not in violation, yet making the decision to keep the age restrictions in place. These issues were brought to the defendants prior to filing complaints with certain agencies and prior to filing my lawsuit, and the defendants continued their actions, which I have proven with a substantial amount in digital evidence collected over the years, which the assigned judge continues to attack in various court orders, in which I also continue to counterattack in reply letters to the judge's court orders, presenting defensive arguments against the judge's false claims and assertions, and attempt to feign confusion as to how I labeled the evidence, despite the judge listing, citing, and attempting to use some of my evidence against me while completely ignoring the remaining amounts of evidence. Plaintiff's response and fulfillment of defendant's request for production of documents and electronically stored information relevant to jurisdiction. Attention, Judge J.P. Stadmuller and the Federal Clerk of Court for the United States District Court, Eastern District of Wisconsin. I, Plaintiff pro se in this legal matter, am submitting this here plaintiff's response and fulfillment of defendant's request for production of documents and electronically stored information relevant to jurisdiction, according to the wording of docket number 48, court order for submission of accounting statements reflecting the plaintiff's actual lost ad revenue. The plaintiff truly believed and currently believes it is impossible to provide such information due to having no information for the actual amount or percentage in ad revenue shares the defendants intentionally kept from the plaintiff, which is why the plaintiff is currently suing the defendants for $25 million in punitive damages due to the defendant's unwarranted and unprovoked actions against the plaintiff's character, the plaintiff's YouTube channel, and the plaintiff's YouTube video content. The defendant's request via Sopen B. Shah of the Perkins Coy law firm is much more sensible and attainable. The plaintiff has included 5 personal banking statements reflecting 5 deposits via Google LLC dating back to 2016 2017 through 2020, and also the plaintiff's Google AdSense revenue information dating back to 2016 through 2021. Sensitive information removed from banking statements. No direct deposits were made by Google LLC in 2016, beginning 8/24/2016, due to the $100 threshold not being reached until the month of January 2017. No direct deposits were made by Google LLC after 12/21/2020 due to the $100 threshold not being reached prior to 9/3/2021, leaving the current earned ad revenue dollar amount frozen at $56.29 prior to and after the plaintiff's YouTube channel was completely demonetized by the defendants on 9/3/2021. The information gathered from Google AdSense in relation to the total number of 5 direct deposit payments made over the course of 3 years and 10 months between 2/22/2017 and 12/21/2020, totaling $538.76, does not exonerate defendants Google LLC and YouTube LLC, but poses more questions despite no actual answer being filed by the defendants to the plaintiff's lawsuit. Question number 1. What motivated the defendants to breach their contract with the plaintiff beginning 2017, soon after the plaintiff's video content began earning revenue? See evidence folder titled 1. Proof, constant flagging, unflagging, and reflagging, and more. The plaintiff has even more evidence proving the flagging and reflagging cycles continue into 2020, which continues to prove that defendants continually breach their contract due to the constant flagging, unflagging, and reflagging cycles, greatly outnumbering the 5 direct deposit payments made by Google over the course of nearly 4 years, calculating untold much larger ad revenue amounts earned by the plaintiff but kept by the defendants. Question number 2. What motivated the defendants to engage in more unwanted and unprovoked actions against the plaintiff's YouTube channel after exposing the incessant flagging, unflagging, and reflagging cycles, such as falsely claiming violent content when there was none, and age restricting the plaintiff's videos that were not in violation of community guidelines? Then going a step further with emails sent to the plaintiff stating the videos that were not in violation, yet decided to keep the plaintiff's videos age restricted. Question number 3. Why do the defendants feel they can get away with making false accusations against the plaintiff, such as accusing the plaintiff of lying about the video content, alleging violence, and stealing other YouTube channel content, and uploading alleged stolen content to the plaintiff's YouTube channel without providing any proof whatsoever of the alleged violent content and stolen content, and in the process defame the plaintiff's character? Question number 4. Why was the plaintiff's YouTube channel ever targeted to begin with? Was the plaintiff's YouTube channel randomly targeted? Was there an office pool to see who would win the pot after betting on when the plaintiff would give up and walk away? Message to Sopen B, Shah, Judge J.P. Statmuller, and defendants Google LLC, YouTube LLC, and Alphabet Incorporated. I, as the plaintiff pro se in this legal matter, have no intentions on walking away from this lawsuit and intend to pursue this lawsuit and will fight tooth and nail to expose the defendant's actions, Judge Statmuller's actions, and your actions, Sopen B, Shah, as you all continue to engage in acts that prove a low moral compass in the attempts to have my lawsuit dismissed on meritless motions and continued delays with subject matter jurisdiction briefs and accounting statements, which I will continue to supply no matter how many court orders are issued, and will exercise all appeals afforded to the plaintiff as of right. These are the issues I intend to expose, which the plaintiff feels were intentional. 1. Judge Statmuller never answering my motion to proceed without paying the filing fee after patiently waiting 271 days. It's possible the assigned judge reviewed my lawsuit, saw the strong evidence and decided to ignore the plaintiff's motion, with the possibility of the plaintiff never being able to pay the filing fee. Motions are usually answered within 30 to 90 days maximum. 3 full 90-day cycles passed as my motion went unanswered, compared to the defendant's motions being answered and granted immediately or within 90 days. 2. Plaintiff's lawsuit being entered incorrectly after filing. Plaintiff sued under 28 United States Code 1332, yet plaintiff's lawsuit was entered under 28 United States Code 1331. Plaintiff's demand in the initial lawsuit and subsequent amended complaints was for $25 million in punitive damages, yet the demand amount entered by the federal clerk of court read 25,000 and was only recently changed due to a request via a phone call from the plaintiff to the federal clerk of court on 5/19/2022. The demand amount now reads 25,000,000. Filing date for the plaintiff's lawsuit was on 12/11/2020. 3. Sopen B. Shah, you offering the pro se plaintiff assistance in filing the waiver of the service of summons on 3 occasions, going a step further in offering your hand in further assistance if I needed any additional information. 2 occasions have already been proven via the body of the email request for evidence and the body of the evidence request letter submitted with docket number 12 titled Plaintiff's Demand for Counsel for the Defendants to Refrain from Offering Plaintiff Assistance, which was filed on 10/28/2021. If you will recall, Sopen B. Shah, your first offer was during a personal phone call to my cellular phone on Monday, October 11, 2021, around 2:45 p.m. I stated that I made the trip to the clerk's office on Columbus Day, which I had no idea was on that particular day. I declined your verbal offer to file the document for me and stated that I would be returning to the clerk's office the next day to file the waiver of the service of summons. The reason I did not bring up the phone call you made to me was due to the call being hearsay, being my word versus yours, and due to this, I never brought the issue to the clerk of court or the assigned judge. Honestly, Sopen B. Shah, there should be some type of reprimand for your actions for opposing a conflict of interest, being you represent the defendants and you engage in offering the plaintiff assistance who is suing the defendants you presently represent. Sopen B. Shah, would you have offered your assistance if I were represented by a licensed attorney? I don't think so, but you felt you could offer me assistance due to being a pro se litigant, assuming I lacked any knowledge or common sense. 4. Document tampering. Plaintiff's 8-page reply, docket number 35 to docket number 31, a court order for submission of subject matter jurisdiction briefs. 3 pages were omitted from the digitally scanned record at pages 2, 4, and 6. It appears the assigned judge didn't take kindly to the pro se plaintiff countering the judge's false claims and assertions, among other things. If you read pages 2, 4, and 6, I addressed this issue with docket number 42, supplying both versions of docket number 35, omitted and full. I, as the plaintiff pro se in this legal matter, in pursuing this lawsuit, have nothing to lose because the defendants took away everything I had to gain after starting/building my YouTube channel. Submitted to the Federal Clerk of Court for the United States District Court, Eastern District of Wisconsin, on this 20th day of May 2022. Thank you.